Judge, so it sounds like she missed her blows when she was working. She's clean. I don't know if we can go do a test today to prove that. I did notice that we're set for jury trial on the 25th. The only issue I have with that is I didn't realize that I'm set for an ag assault out of Orange on the 24th. So I would be asking for a reset of that jury trial date. As far as the bond violations today, I've explained to her the importance of
No.
Third time's a charm, or in this case, third time's a sell. Welcome to another gripping session in Judge Flea's courtroom, where repeat offenders face their final warnings and excuses hit a brick wall. Today, we're witnessing a defendant who's missed test after test and is now begging to attend her son's graduation. But will a judge show mercy or enforce consequences? We've got a man pleading guilty to assault with life-altering consequences, including losing his gun rights forever. There's a homeless defendant getting one last chance, with resources being handed to them on a silver platter. And wait until you see the guy who drank an entire bottle of tequila on Valentine's Day and threatened to have someone shoot up his girlfriend's house. From federal court paperwork confusion to ankle monitor malfunctions, protective orders to probation extensions, this docket is everything. Judge Flea is balancing compassion with accountability, and not everyone is going to like the outcome. Let's dive in.
No. We've done this before. This is our third time being back. It's unacceptable. I can't just let her go. Then I become an enabler and I'm telling her it's okay for you to do whatever you want to do. And it's not. You know, if you have an issue, you come up to here, you tell us what it is, and then we can resolve an issue. But I can't just let her go when it's a third violation. No, you're skipping test after test after test after test. This is your third time back on bond violations. It's unacceptable. No. She goes with you. Sorry. You're skipping tons of tests. It's your third time coming back for bond violations. Unacceptable.
Donna, please, my son's graduation is coming. My son's graduation is coming. Please,
I'm not going to talk to you without your lawyer. You scare me. You know, all I asked you to do was not consume while you were on bond, and you were incapable of doing that. You know, the idea is that you learned something. I know that you say yes, I get it, but that you truly learn something. Because, yeah, this is the first here. How many times has it been in reality? You know, you have to understand that from now on, anytime you get pulled over, an officer will see this. If they smell alcohol on you, what do you think they're going to do? What?
I don't want to take a breath.
No.
Go to the end.
Right. That's what's most probably going to happen. And what we're doing today, the proverbial slap on the wrist, from now on, you are facing a minimum of 30 days in jail. The idea is that you learn to where if you're going to endanger yourself, okay, but don't endanger other people. God forbid you make some kind of catastrophic mistake where you're looking at 30 to 40, 50, 60 years, because every day it happens in Harris County. Every day someone dies from alcohol-related collision. And it's not fair when $30 will get you anywhere you want to go with one click of a button, man. You know what I mean?
Yes.
This is one of the most emotionally charged moments we've seen in this courtroom. The defendant is pleading, literally begging, to be released so she can attend her son's graduation. And Judge Flea's response? You scare me. That's not anger. That's genuine concern from a judge who has seen what happens when people don't learn their lesson. This is her third time back for bond violations. She's been skipping tests repeatedly, showing a pattern of noncompliance. And here's the reality check the judge just delivered. Every single time she gets pulled over from now on, officers will see her record. If they smell even a hint of alcohol, she's going straight to jail, no questions asked. The judge mentioned that people die every day in Harris County from alcohol-related collisions. That's not hyperbole. That's statistical fact. And his point about rideshare apps costing $30? That's the most practical advice anyone in this courtroom will hear today. For the price of a meal, you can avoid destroying your life and potentially ending someone else's. The The graduation plea is heartbreaking, but accountability doesn't pause for life events.
You give up a lot of rights by entering into this agreement today. What you're doing today is you're making a lifetime decision. So don't take it lightly, because once you plead guilty to this offense, there's no turning back. You cannot come back tomorrow, next week, 2 weeks and say, you know what? I changed my mind. I don't want to do this anymore. Once you plead guilty, it will go on your record. It's going to be there for the rest of your life. Do you understand? You give up a lot of rights by entering this agreement, Ms. Galindo. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charged, read in open court. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, there's no turning back. Is this what you want to do?
I'm guilty.
Ma'am, I'm going to find you guilty. I'll send you to 3 days in jail. I'm going to give you credit for 1. I am going to suspend your license for 90 days. Do not drive until you get a license. Let me make one more thing clear to you, that DWI is huge business in the state of Texas. When you plead guilty to this type of offense, there is a $3,000 surcharge that tacks onto you. And if you don't pay it, every $100 you owe, you sit 1 day in jail. I'm not going to hit you up, but a second DWI, you're looking at $6,000. If you come back with another one, get ready. It's a minimum of 30 days in jail, and you're also looking at potential up to $6,000. Get a clue. Good luck, man. Morning, Mr. Johnson. Mr. Johnson, you're charged with 3 total cases. You're charged with assault of a family member, failure to identify oneself as a fugitive from justice, and criminal mischief. It looks like you've worked out a plea bargain agreement. They're going to dismiss 2 of them. You're pleading guilty to the assault case. You need to understand that this carries many, many consequences. There's an affirmative finding of family violence, meaning that if you ever pick up another case like this again, you will be looking at a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And it doesn't have to be a dragged down fight where you're punching and kicking. No. All you do is squeeze someone's arm and it hurts just a bit. They'll hit you with a 3rd-degree felony. You understand? Sure. You can never own a gun or ammunition as a result of this plea bargain agreement today again as well. No more guns, no more ammunitions. Do you understand? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do?
Sir.
How do you plead to the offense of assault of a family member, sir?
Good.
I'm going to find you guilty, sentence you to 6 days in jail. I'll give you credit for the 2 days that you've done. Like I said, there's an affirmative finding of family violence. So you pick up another one of these cases. You understand?
Sir.
All right. Good luck, sir. Please see the clerk.
Yeah.
Judge, I have 2 other cases.
What just happened here is something every viewer needs to understand. Mr. Johnson pleaded guilty to assault of a family member, and with that plea comes what's called an affirmative finding of family violence. This isn't just legal jargon. It's a permanent mark on his record that changes everything going forward. Here's what it means. If he ever gets into another domestic situation, even something as minor as squeezing someone's arm too hard, he's not looking at a misdemeanor anymore. He's looking at a 3rd-degree felony. That's 2 to 10 years in prison. Not jail, prison. And here's the other bombshell. He can never own a firearm or ammunition again. Under federal law, this is permanent. No hunting rifles, no handguns for protection, nothing, ever, for life. The judge also dismissed 2 other charges, failure to identify and criminal mischief, as part of the plea deal. That might sound like a win, but the family violence finding is a burden he'll carry forever. This is why legal representation matters. This is why understanding what you're agreeing to matters. One bad decision can reshape your entire future.
Mr. Quaylar is set for bond appropriate last week.
No. Okay. That's it.
And then
5,001. Or no, I think it's more than that.
Mr. White, Mr. President, spoke to Richard. He's wondering if we can, the felony is reset till 3/25. There's already a deal in place that if, you know, that takes care of, then ours goes away.
John?
Is that, okay, yes, sir. No, sure. You got it.
Judge, there seemed to be an issue with the client coming to court tomorrow. I don't know if his appearance is required, but what we want to talk about.
It's not a big deal.
And he wanted me to also address whether or not you would give him another lawyer. I told him that you have a right to request that.
What's going on?
Yes, I just would like to request another lawyer.
The problem is though, is that, you know, if I give you another lawyer, is the same thing going to happen? I don't, you know,
No, we didn't do it. We didn't try it yet, so you can't say that's what's gonna happen. I don't like get into these things with people because most of the time people are compliant with federal law.
they have their way of doing things, right?
Exactly, I understand.
And so when you start getting into federal law, this and that, it may become an issue. And that's,
When people come to your court, do you care whether they respect what you're saying or not? No, they just have to follow the order. I have a federal judge's order based off of my life, and she made a decision, and it never gets respected. That's why I'm in here. The laws were violated to get here. And I'm a person too. A federal Judge Carolyn Beers, this is her decision.
what is he alluding to, Mr. D, about this federal decision that,
I have the paperwork. I can show you. I tried to give it to you last time and you said you couldn't accept it, but I have it. I can go get it. For you.
I don't get involved with the minutia
I
of,
understand, but it's your courtroom and you're responsible for the court procedures. So I just don't want you and your court to get in trouble because, but I can show you, or I can show him.
no.
But some,
Not talk to the prosecutor, sir. You can't do that. So
I-
my only issue is understand that if I give you another lawyer now,
Yes.
right, if we end up in the same issue,
you have my word because it's going to be better communication.
okay, so let's, Vic, let's go ahead and reappoint, okay? I still want to go through the hearing though, tomorrow though. So I will waive your appearance for tomorrow. You don't have to appear tomorrow, but you have to meet with a new lawyer now so that you can get the information, so you can get together with whoever that person is. And then I want to continue this hearing tomorrow.
Am I supposed to be here?
Yes, yeah, because you were the one who's privy to this whole thing, right?
I was just informed you.
I understand, but I don't think that she understands what the scope of everything is, and I want to get to that.
Yes.
How's jail? Not good, right? We're not asking much. All I'm asking you to do is show up and don't pick up any new cases. You now know you have no one that is going to bond you out. So when you go to jail, you are stuck like Chuck until this thing is over with. Your lawyer has asked for me to give you one more chance. Should I? What are you doing with yourself these days? Why? And where are you living with? Okay, so I have resources for you. We have places that can help you get a job, a phone, a tablet, places to eat, places to sleep. All you got to say is that you want it and we'll try to give it to you. But there's no excuse. That doesn't give you, I get it that you're homeless, but that doesn't give you the right to go in and take some, you know? So don't. All I'm asking you to do is stay in touch with the lawyer that we're giving you and don't pick up any new cases. I will give you another chance, but I'm not going to play this again. You pick up a third case or you fail to appear again, you're going to end up staying with me. Do you understand? Okay. I have Shatoria. She's going to give you a list of places that can help you get a job and places to sleep and food to eat. So there's no excuse. You can always come back here. Whatever you need, come back and I'll give it to you. There's no excuse for you to pick up another case though. You understand? Okay. All right, Anna.
This right here is what separates a good judge from a great one. The defendant is homeless. No job, no phone, no stable place to sleep. And instead of just throwing the book at them, Judge Fleer does something remarkable. He offers resources, job placement assistance, a phone, a tablet, food, shelter. He's literally saying, tell me what you need and I'll try to help you get it. But here's the key. He's not giving a free pass. He's removing every possible excuse. You can't claim you couldn't find work if the court is handing you job resources. You can't say you had nowhere to go if they're providing shelter information. This is accountability with compassion. The judge made it crystal clear. Being homeless doesn't give you the right to steal. That's the balance. Understanding someone's circumstances while still holding them to a standard of behavior. One more chance. That's it. Pick up a third case or fail to appear, and you're staying in custody until your case is resolved. No one to bond you out. Stuck like Chuck, as the judge said. This is what second chances look like when they come with real expectations attached.
Judge, are we reinstating?
Yeah.
And what about bond conditions?
So bond conditions, so I don't want you to go back to any of the places that you picked up the theft cases from. You're not allowed to go back there. Do you understand? I don't want you to be in possession of weapons as well. As long as you can abide by this and get a job, you and I are cool and stay out of trouble. All right, Mr. Rodriguez,
Yes, Your Honor.
you have been indicted on the assault case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Do you know which case we're talking about?
The first one?
So let me have them read it to you just to give you a bit of a heads up so you know what we're talking about.
Yes, Judge. On December 24th, 2024, the officer was dispatched to location and made contact with the complainant. The complainant stated he followed his sister when she left the house to come get her back, and the complainant ran into the defendant, the complainant's sister's ex-boyfriend, and told the defendant he could not be around the sister. The defendant walked up to the complainant really close. The complainant pushed the defendant to get some space, and the two got into a physical altercation. The complainant stated the defendant bit the complainant's left arm in between the altercation and then ran away. The complainant complained of pain and was advised by EMS to get stitches.
Okay, so I'm going to set you a bond now of $5,004, which is what all the other bonds are at. And then, Anna, it looks like the felony case is set for March 11th.
Okay.
Do you want to do the day after?
Yes. And his other misdemeanors are on March 12th as well. So that'll be perfect.
Got it. Okay, so we're going to do it one day after the felony, and then you guys, once,
That's fine.
we're going to try to work a global resolution so that it's all done at once, okay?
Thank you, Your Honor.
Okay, man. So just don't have any contact with the complaining witness in this case and no weapons. I don't know if you're going to bond out, but those are the conditions on this.
Yes, Your Honor.
Okay.
Of course.
Okay.
Judge for Taylor, is that a regular recess? And the state's.
Anna, what do you want to do with Mr. Taylor?
Can we do a regular reset? Because his cases are both fairly new and I don't have anything on them yet.
Okay, so this is Anna. That's the one lower left. She's your lawyer. That's who you need to stay in contact with. If she tell me she can't get a hold of you because you're ducking and dodging and you're out there and you're not keeping in contact, I'm going to revoke your bond. You understand? I'm not asking much. Okay. So he needs to sign conditions real quick and then they can both go back.
Okay. And what day on Mr. Taylor?
How's March 18th through the 20th?
Can I do the 20th?
All right, is that a required appearance?
Yes, please.
I would say yes. Yeah. Yeah. Okay.
There's somebody else back there that has hers also. This-
Okay. Yeah, she knows.
Yeah.
Thank you, Mr. Rodriguez. Okay, guys, take care. So, Mr. O'Quinn, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On November 3rd, 2024, officer made contact with the complainant witness who reported an incident from October of 2024. The complainant witness stated that she and the defendant were in a dating relationship for 2 years and share one child. The complainant witness stated that she and the defendant got into an argument in a car. The defendant pulled over and grabbed the complainant witness by the hair and pulled, causing pain, and then, quote, slung the complainant witness to the ground, causing the complainant witness to have a tooth knocked out and bruises to her face and shoulder.
Okay. Have you spoken to the complaining?
I haven't been able to get in contact with her.
Okay. So, Mr. O'Quinn, I'm going to find that there's probable cause to go forward with your case. I'm now entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Daruvala as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
So
If you violate this court order, the state can and probably will file a violation of a protective order against you, and it's one of the worst cases you can pick up. I am ordering you not to have any contact and not to be in possession of weapons throughout the pendency of this case. Do you understand? As long as you can abide by these conditions, you and I will be best friends. If I find that you're violating it in any way, I'm going to revoke your bond. I'm going to put you in jail. That's it. I will do everything in my power to protect the public. Do you understand, Mr. O'Quinn?
May we have no threatening or harassing contact? It's, this incident was said to take place in October.
I don't know because they've not been able to contact her.
That's what is in their report. It says that this happened in October.
I get,
Okay.
but he's not being able to have contact with her, and I want to abide by her wishes, and I don't know what she wants. Until I know what she wants, then we can talk, but I don't know,
What's your question? Not right now, you're not able to do anything until they talk to her and then.
Right, I want to know what her perspective is, whether she wants to have contact with you. How do I know that she wants to hear from you? I don't know that. So I always want to honor the wishes of a complaining witness first and foremost. So
And I can just step out real quick and try again just to see if, I get an answer.
it's up to you. I mean, don't rush it. We can always come back later. Well, hold on. We still need to work on the bond. So I don't see any. No. Well, let's do the bond first. So I don't see any prior criminal history. Do you?
Yes, so from history, he's been here 6 years, his family's here, the child is here.
So you guys have a child together?
Yes,
How many? One or two?
One.
Okay. So I'll set your bond at $100, Mr. O'Quinn. I'll grant you a PR bond. This is the only one that you're going to get. If I find that you're a danger to my public, you pick up a new case, you start acting a fool in the free world, no more PR bonds. I will revoke your bond. I will issue a warrant and I'm going to put you in jail. You understand? You've got a great lawyer. Listen to her. She'll take care of you because you have a lawyer. I would waive your appearance. You don't have to waste your time coming to court every month, but you got to stay in touch with her and she'll tell you if and when you have to come back to court. All right. All right. Now we're done with everything that I need to do. So you guys can step back. If you're able to get in contact with her at that point, you guys can reapproach and then we can amend the MOA. But other than that, we're done. All right.
Thank you. Quick approach, Judge, back on O'Quinn. I think they were able to speak to the complaining witness.
Yes, we were able to speak with him. Sebastian was able to make contact with her, and he's fine with no threatening, harassing as a condition.
He's in the box.
Come on. So,
And just so we're clear, Judge, I know you mentioned like a 200 feet restriction. And so they spoke
We're
to
good
her
with
about.
removing that.
and so I will take off the residential restriction and I'm going to order you not to any threatening or harassing contacts. Just be careful. Like I said, I don't know what kind of relationship you have with this person, but if you're constantly butting heads, be very careful. You know what I mean? A lot of vindictive people in this life. Got to know who your audience is. Okay, man. Good luck.
Thank
We'll
you.
get it done. No, I don't. Excuses go in one ear and they go out the other. I don't.
That changed. But it was something wrong with that device. I got a whole.
They're saying it. There's nothing wrong with it.
I got a whole new one. And I even started to do put it on a new one. It was too tight. I went back to
You must charge the thing every.
It was because it makes like a sound when you plug it in. It says charging begun, and then when you unplug it, it says charging has stopped. And then I called 2 days before the 10th, the 7th or the 8th, and I told him it's not making the noise no more. So I wouldn't know if it was charging or not charging or dead or nothing. It wouldn't talk to me no more.
Here's a situation we see more often than you'd think. Defendants blaming monitoring devices for their violations. The defendant is explaining that the ankle monitor wasn't making sounds, wasn't charging properly, was too tight. Essentially a laundry list of technical issues. And Judge Fleer's response cuts right through it. Excuses go in one ear and out the other. Here's the reality that defendants need to understand. When you're on monitor release, That device is your lifeline, the freedom. If it's malfunctioning, you don't wait until it becomes a problem. You report immediately and document everything. You call, you email, you create a paper trail. Because when you're standing in front of a judge explaining why you miss readings, the device was acting weird, isn't going to hold much weight without proof that you reported the issues in advance. The judge gave a final warning, and that phrase, "you and I will have a problem," is as serious as it gets. This defendant is one more issue away from having their bond revoked entirely. At some point, personal responsibility has to kick in. The device is a defendant's responsibility. Charging it, wearing it properly, and reporting any issues before they become violations.
I don't want any more issues.
Sure.
We have any more issues, you and I will have problems. It is your responsibility. No more.
Sure.
All right, take a seat for me. I'll continue it, Rick. Any more?
It
That's,
was originally on March 6th, as one percent.
do you want to keep March 6th?
Yes, Judge, we'll keep that date.
Okay, is discovery complete?
Yes, Judge. Discovery's complete.
Put an offer on the case?
There's a time served offer.
There is now? Time served, okay.
I had people working on it for.
I'll discuss
Well,
with
they
you.
may be working on a mitigation, but. All right, Rick, it's in you. We'll see you March 9th, okay?
That'd be fine, Judge. Thank you.
All right, friend, or 6th, sorry.
Yes, that's correct. Thank you, Judge.
All right, Ben. Mr. Brown, you are charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On February 9th, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. Upon arrival, officers met with the complaining witness, who stated that she and the defendant are married. The complaining witness stated that the defendant and she got into a verbal argument over prior infidelity. And the complaining witness stated that the defendant cornered her and headbutted her 5 times in her face, causing pain.
Any alcohol, anything like that as an allegation?
Judge, I don't believe so.
Mr. Brown, I'm going to find that there's probable cause to go forward with the case. It appears that a protective order has been issued in this case. Get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. What I normally do is I order no contact and no weapons unless I know that the complaining witness wants to have contact with you. At that point, if they do, I order no threatening or harassing contact. But you have to understand what is threatening or harassing. Doesn't matter what you think is threatening. I could care less what you think. It's what the other person perceives. So if I go like this, is that threatening or harassing? It most certainly is. And it can violate this court order and land you in jail. I don't know what kind of relationship you have with this person, but if it's something where you're constantly butting heads, there's a lot of vindictive people in this world. You got to be careful because you're the one that's on bond for this case. If they call and say, "Hey man, you're the one that's going to end up." You know what I mean? So those are the conditions now. Are no threatening or no harassing contact. I'm sorry, no contact and no weapons. I'll have Sebastian reach out to her. If she wants to change it, then you guys come back, let me know, and then that's what we do. All right? Okay, guys. Now, hold on. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him. If he tells me he can't get a hold of you because you're ducking and dodging, or you pick up a new case, or you're a danger to my community, I only have one place for you. You understand? Just all I want, be nice. That's all right? Okay, please.
Thank you, Judge.
Thanks, guys.
On the Melania Smith matter, there's a issue about an extension of her probation.
She sounds like the drug program judge.
Oh.
They requested a 3-month extension.
Where is Miss Smith?
She's here. Who is that?
Come up, Miss Smith.
The request was sent last week. They wanted 3 months for her to complete IFC SOP. She completed it over the weekend. Ashley granted a 3-month extension. We wasn't sure if they want to wait or. He's supposed to get off probation March 1st, but she owes $325. So we're waiting to see now if she wants to continue the extension or just allow her to.
Have you paid that money off?
Yeah, I just looked at it, it's $230. recently, like in the last 20 minutes, just paid that.
Oh, great. So everything's paid off.
Well, they're delinquent. According to my probation officer, he said if I was in good standing, then everything else, I wouldn't, I mean, there wouldn't be anything else I would actually have to pay. I finished.
I know. I think that you're supposed, I don't know.
He's supposed to get off March 1st. Initially, the extension was requested for IFPS. They said that she's satisfied that, they're okay with allowing her to terminate.
Great.
But because she has a $325 balance, they didn't make a decision on a 3-month extension.
But now she's satisfied that, right? So,
I don't see that on my end yet. I can double check.
so why don't we do this? Why don't we postpone it till later in the week? Because it takes those,
$220. I have my bank account that I can show.
no, but it has to reflect in the system though. Don't worry. It's not the end of the world. I'm sorry.
Swear today.
I can waive your appearance. Don't worry about it. You know? But you can be here, right? Because if you've done everything that you've done, hopefully they're satisfied with everything and then we can be done once and for all. If you've paid what you need to pay and you're not delinquent anymore, that was all that was needed for it to happen, right? So hopefully that's sufficient for them to say, okay, we're happy. But it might take like a couple days for it to hit the system. That's the only problem. So why don't we postpone to Thursday? I'll waive the appearance. That way you don't have to miss a day of work. Come back. If they're okay with it, then they dismiss. If not, then we'll, I guess, cross that bridge when we get there.
If it's okay, I can make the appearance on Zoom.
Please, that's why we have it. Yes, absolutely. Yeah. Okay, yeah, so can you email them, Alex, and say, hey, that everything's done, she's paid?
I wasn't understanding. Could you also, because the amount, I'm not sure. Yeah. Yeah, can you forward? Yeah.
Just stay in contact with him. That's it. Okay,
We can go and say no more.
yeah,
Okay.
have fun.
This is
Mr. Guevara, you were charged with driving while intoxicated. It's elevated to a Class A misdemeanor, so you are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 90 days in jail with credit for the 29 days that you've done.
Yes.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it stays like this on your record forever. Do you understand?
Yes.
Now he has, that he has 2 open DWIs?
Yes, to Your Honor, we're dismissing one.
Dismissing one.
Yes, Judge.
Does he have an immigration detainment? You know?
I believe he does.
Yes, he
Your
has a
Honor.
hold, he said.
Mr. Guevara, is it true or untrue that you had a .15 or above? How do you plead to the offense, so guilty or not guilty?
Guilty.
Fine you guilty. I will send you to the 90 days in jail. I am going to suspend your license for 1 year. Do not drive. You know, from now on, whenever you get pulled over, an officer is going to look at your record and they're going to see DWI. DWI. If they smell alcohol on you the next time you get pulled over, it's probably not going to go well for you. A 3rd DWI, you're looking at a 3rd-degree felony up to 10 years in prison. Do you understand? Get a clue. Good luck, Mr. Guevara.
Thank you, Your Honor.
All right. You are Mr. Nieto. Mr. Nieto, you are charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 14th, 2025, the officer was dispatched to a disturbance family call at a residence in Harris County, Texas. The officer made contact with the complainant who stated the defendant had already left the location and was down the street wearing a black sweater and blue jeans. The officer made contact with the defendant, who matched the description. The complainant stated she was washing dishes when she received a phone call from the defendant, who wanted to celebrate Valentine's Day with her and that he was coming over. The complainant noticed when the defendant arrived, he had already been drinking alcohol and brought over a new bottle of tequila. The defendant entered the residence, drank the entire bottle, and started belligerently yelling about his ex-wife. The complainant asked the defendant to leave. The defendant refused, and the defendant started breaking items in the house and threw a vase at the complainant, which she was able to dodge. The complainant eventually got the defendant out the door, and the defendant then threatened the complainant, stating, "If you don't let me inside the house, I'm going to send someone to shoot up the place." He said this several times. The complainant was in fear for her life, and the complainant is in a dating relationship of 5 years with the defendant, and the two live together.
Valentine's Day is supposed to be about love and romance. Instead, this turned into a nightmare straight out of a true crime documentary. Let's break down what allegedly happened. The defendant shows up already drunk, brings a bottle of tequila, drinks the entire bottle, and then starts yelling about his ex-wife at his current girlfriend's house. When she asks him to leave, he starts breaking things and throws a vase at her. But here's where it escalates from bad to terrifying. "If you don't let me inside the house, I'm going to send someone to shoot up the place." He said this multiple times. This isn't just harassment. This is a death threat. And they've been in a relationship for 5 years and lived together. That detail is crucial because it establishes a pattern of behavior and makes a protective order even more necessary. The complainant was literally doing dishes, minding her own business, when this chaos erupted. Notice how Judge Fleer immediately orders no contact, no alcohol, no drugs, and random testing. He's not taking any chances. Every phone call from jail is recorded, and the judge makes sure the defendant knows it. One wrong word on those jail calls, and additional charges could follow.
What are you requesting?
We're requesting a mow-up, Your Honor, and no contact with the complainant.
I see a protective order has already been issued.
Has there been issued, Your Honor? Yes. So we're just wanting to make sure this one issued. Okay.
So understand, Mr. Nieto, that I'm going to find that there is sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person, not to consume alcohol or illegal drugs, and to undergo random testing. The protective order has been issued. I would get to know it. If you do something to violate the protective order, the state can file more charges against you as violation of protective order. If you ever have any questions about what you can and cannot do, you can ask your lawyer and she can tell you what you can and can't do. Just be careful while you're in the jail, as all phone calls are recorded. Anything else?
Okay, that's all.
Okay.
We're waiving a bail hearing on both of these. So that's okay.
Okay. All right, Mr. Nieto, good luck to you and good luck to you, sir. Okay. Thanks, guys.
And that concludes another powerful session in Judge Fleer's courtroom. A session that perfectly illustrates the complex balance between justice, compassion, and accountability. Let's recap the major moments we witnessed today. First, we saw a defendant facing her third bond violation for a DWI case, desperately pleading about her son's upcoming graduation. Judge Fleer's response was unflinching. "You scare me." The message was clear. 3 strikes on bond violations means custody, no exceptions. She pleaded guilty and received 3 days in jail, a 90-day license suspension, and a $3,000 surcharge that could land her back in jail if unpaid. We covered Mr. Johnson's assault case, where a guilty plea came with an affirmative finding of family violence, permanently stripping his right to own firearms and setting him up for a third-degree felony if he ever picks up another family violence case. That's 2 to 10 years in prison for something as minor as squeezing someone's arm. One of the most unique moments was a defendant attempting to introduce federal court paperwork into a state proceeding, trying to argue that federal law should supersede. Judge Fleer handled it diplomatically but firmly. They just have to follow the order. We watched the judge offer real resources to a homeless defendant, job placement, phones, tablets, food, and shelter, while making it crystal clear that homelessness doesn't excuse theft. The assault cases kept coming. One involving a Christmas Eve altercation, where the defendant allegedly bit the complainant's arm requiring stitches, and another where a husband allegedly headbutted his wife 5 times during an argument about infidelity. Protective orders were issued, and both defendants were warned about the severe consequences of violations. Finally, we covered a Valentine's Day harassment case that went from romantic gesture to death threat when a defendant consumed an entire bottle of tequila and threatened to send someone to shoot up the place. Throughout every case, Judge Fleer's approach remained consistent. Explain the consequences clearly, offer resources where appropriate, and make it absolutely clear that violations will not be tolerated. Stuck like Chuck has become a courtroom catchphrase for a reason. When you burn your bridges with bond violations, there's no one coming to save you. So here's our question to you. Do you think Judge Fleer strikes the right balance between giving second chances and holding people accountable? Or should the system be stricter from the start? Drop your thoughts in the comments. We read every single one and love hearing different perspectives. If this video showed you a side of the justice system you've never seen before, make sure to smash that like button. It helps more people discover these important courtroom moments. Share this video with anyone who thinks the legal system is just about punishment. Because as we saw today, it's also about prevention, education, and giving people the tools to turn their lives around. And if you haven't already, hit that subscribe button and click the notification bell so you never miss another episode. We break down real courtroom drama, explain the legal implications, and show you how justice actually works in America. Remember, the decisions you make today follow you forever. A moment of anger becomes an affirmative finding. A night of drinking becomes a criminal record. A threat made in frustration becomes a felony charge. Think before you act. And if you find yourself in Judge Fleer's courtroom, listen to your lawyer and follow the conditions. Until next time, stay safe, stay smart, and we'll see you in the next one.